Good afternoon, my lord. Ventisei for the pursuer. My lord, this case calls at a diet of debate, and as my lord is aware, this is an action for payment. There is also a counterclaim to this action, however, this is not an issue up for consideration this afternoon. My lord will see from the closed record, and my lord will also have the pursuer's first inventory of productions numbered from 5/11 to 5/113 of process. My lord will also have the pursuer's Rule 22 note and the pursuer's list of authorities. My lord, it would be my motion this afternoon that your lordship sustains the pursuer's plea in Law 1 and repels the defender's plea in Law 1, 2 and 6. I'll then move, my lord, on that basis to grant a decree in favour of the pursuer for the sum of £18,000. Does my lord require a brief summary of the background of the matter? I'm obliged. The pursuer supplies building materials to the trades, and the defender is a building company. The pursuer contracted with the defender on 12 separate occasions to supply asphaltic road surface material. On 2 of these occasions, the pursuer delivered the material to a site in Alloa. On a further 2 of these occasions, the materials were delivered to a site in Edinburgh. On 7 of those occasions, the materials were delivered to a site in Kirkcaldy. And on 1 of those occasions, the materials were delivered to a site in Bothwell. This action has been raised because the defender has not paid the pursuer for the materials that they have supplied. The defender has pled retention on the basis that there is a counterclaim, and it will be my submission that this is invalid in law, given all of the facts and the circumstances. And so in making my submission, I will invite my lord to make 3 key findings. Firstly, I will invite my lord to find that it is trite law in Scotland that a liquid sum cannot be offset against an illiquid claim, and a plea of retention is not competent in such circumstances. I will secondly invite my lord to find that the facts and all the facts and the circumstances of this case are such that they fall out with the mutuality principle. The pursuer has provided goods and has performed their side and obligations under their side of the contract, and indeed under 5 separate and distinct contracts, and is entitled to payment therefore. And thirdly, I will invite my lord to find that this is not a matter where it is appropriate to use judicial discretion to find against the pursuer, and the sum sued for by the defender in their counterclaim cannot be instantly verified. In short, my lord, I'll explain the law in this matter, I will apply the facts to the law, and deal with the exception. Is my lord happy for me to move on to my substantive argument? I'm grateful. My lord, it is trite law in Scotland that where a party is subject to a contract, that party cannot retain sums due to the other under that contract, where the sum is liquid and you're seeking to offset an illiquid claim. I appreciate that there are exceptions and conditions to this rule, and I'll go on to discuss these slightly later in my submission. However, the starting point for any discussion surrounding the rule of retention is naturally the UK Supreme Court judgment of Inveresk plc against Toulouse Russell Papermakers Limited, which was heard on the 1st and the 2nd of March 2010 by the UK Supreme Court. Now, I appreciate the Mortal Lord may be well aware of the case, having read the papers in advance. However, it may be helpful to the court for me to give a very brief background to the matter. This was a dispute surrounding intellectual property rights between two paper manufacturers. The parties in question sought to transfer IP rights in a brand of paper by way of two contracts. Contract 1 dealt with the asset purchase, and Contract 2 dealt with the ongoing services agreement. The pursuer Inveresk plc, who sold the brand to the defender, sued for £909,395 under the asset purchase agreement, and the defender counterclaimed for the sum of £5,358,032.90 under the services agreement. Now, in this matter, there were two issues for the court's consideration. The first concerned additional consideration, and the second dealt with retention, and it is the latter of these two which is of relevance this afternoon. My Lord, at Lord Hope's judgment at page 16, does my Lord have sight? I'm grateful. His Lordship considered that in Scotland, cases where retention of debts is permissible form the exception to the rule that an illiquid claim cannot be offset against a liquid claim. In simple terms, it can be said that when a sum of money or other consideration can be agreed upon, and that is quantified, this cannot be offset against the debt which is yet to be verified. In practical terms, verification realistically is the subject to a proof. There is, however, an exception to that rule, and the conditions of that rule are very strict and very narrow. It may be possible to offset a liquid sum where the illiquid claim admits of instant verification. Again, in practical terms, that would mean that the illiquid claim would have to be so blindingly obvious that a finder in fact or in law would be able to take a view on said sum. An example would be perhaps where a tenant withholds their rent against the landlord's claim for a broken window, where there's a clear and defined price which nobody could reasonably argue against. A second condition to the exception of the general rule is where both the liquid and the illiquid claim arises out of a mutual contract. Now, this is slightly less obvious and more contentious than it may first really appear, and I think that accordingly it deserves some discussion at this stage. Now, it's my submission that a mutual contract is not the same as a continued course of dealing, but is one that is confined to mutual transactions. I accept that a mutual transaction can be made up of more than one single contract. Indeed, that was the case in Inveresk. However, may I refer, my Lord, to paragraph 42 of Lord Hope's judgment, where he states that although he was right, he's referring to the Lord Ordinary, to reject the argument that it was fatal to the plea of retention that the obligations referred to arose out of a different contract, he did not carry his finding that the separate agreements were all part of the same transaction to its logical conclusion. The guiding principle is that the unity of the overall transaction should be respected. My lord, it is clear from the UK Supreme Court's judgment that it is the transaction that defines the mutuality principle, not the pieces of paper making up the agreement. This means that any plea of retention will fail in the event that a defender seeks to offset the pursuer's liquid sum while there are cross-transactional claims. Now, the third and fourth condition to the exception of the general rule regard bankruptcy and judicial discretion. I will deal with the latter of these two further on in my submission, whilst the former is irrelevant to the matter. May I refer, my lord, to the case of Barton Distilling Scotland Limited against Barton Brands Limited. This case was heard by Lord Osborne in the Outer House of the Court of Session and was reported at page 1261 of the 1993 edition of the Scots Law Times. Now, this was an action between a whisky supplier and a whisky distributor. The pursuer sued for sums due by the defender, and the defender counterclaimed for sums they averred were due to them due to a loss of profit for which the pursuer was allegedly accountable. It was agreed that the pursuer's claim was liquid with a value of £222,740.05, whilst the defender counterclaimed for the sum of £413,000. And the £413,000, it was agreed, required a proof and was thus illiquid. At page 1269 and at paragraph A of Lord Osborne's opinion, the Lord have that? I'm grateful. His Lordship stated that to justify retention, I think that the liquid and illiquid claims must arise directly out of the same contract. A course of dealing is not the same thing as a general account. I would be prepared to recognise the possibility in principle of the quality of mutuality attaching to two or more separate contracts, provided that the parties to those contracts had agreed that that would be so. There's a final caveat to the rule that you cannot offset a liquid sum against an illiquid claim, which I expect my friend, the agent for the defender, to raise in their submission, which can be found in Lord Drummond Young's opinion in the case of Purac Limited against Bizac Limited, and that was reported at page 37 of the 2005 edition of the Scots Law Times. His Lordship held that where it would threaten the benefit the defender might reasonably expect to obtain from the parties' contract, retention might be validly pled. Now, I have two submissions regarding this. Firstly, I respectfully submit that Lord Drummond Young erred in law on this matter on the basis that the UK Supreme Court, only 6 years later, placed absolutely no weight on this opinion. Secondly, even if my Lord chooses to agree with his Lordship, this in practice is actually no different to the judicial discretion principle, which I'll come on to slightly later on. So, in short, the law is clear. A liquid sum cannot be offset against an illiquid claim unless the two arise out of the same contract, or rather the same transaction, or the illiquid sum can be instantly verified. I'll now move on to my second submission, where I will explain why neither of these conditions have been met by the defender and why there is no good reason why decree of £18,000 should not be granted this afternoon. My lord, the pursuer entered into 12 separate contracts, indeed 12 separate transactions with the defender to provide road surfacing materials to sites in Alloa, Edinburgh, Kirkcaldy and Bothwell. The defenders in their written pleadings have admitted that the pursuer provided these materials, and it is submitted on the basis that the defenders have not raised issue with the supply of those materials, that the pursuer have fulfilled their performance in terms of Alloa, Edinburgh and Bothwell, indeed on 5 occasions. So prima facie, the pursuers have a liquid claim of £18,000 plus the interest thereon. This sum is the total sum due under invoices 4, 5, 6, 7, 8. 4, 5, 6, 7, 9. 3, 4, 5, 6, 7. 3, 4, 5, 6, 8. And 7, 6, 5, 4, 4. The defenders in their pleadings have provided no good reason why they have not paid the pursuer, nor have they expressed any problems with the materials or the service that the pursuer has provided for them on those 5 occasions. An argument remains to be had about the supply of materials to the Kirkcaldy site, and the pursuer avers that the materials provided to the Kirkcaldy site were in good order and were inspected by the defender, and that the defender expressed their satisfaction with the materials. The defenders aver that the materials were not delivered to the Kirkcaldy site at the correct temperature, and as a result they were not fit for purpose. Now, the defenders in their counterclaim sue for £95,000, and that is the sum of the removal and replacement of what they aver to be defective goods. So this may seem to be an easily verifiable sum, and therefore it would perhaps follow that retention could be validly pled. However, this is not the case. I'd be grateful if my lord would turn to the schedule of losses for the defenders. My lord will see that the defenders sue for sums paid to defenders' employees to rip up and remove products supplied by the pursuers. They sue for the sum paid by the defenders to the employees to relay asphalt on the site. They sue for the sum paid for the supply of the new materials. They sue for the cost of the hiring of plant to rip up and dispose of the original material. And finally, they sue for the interest paid to the defender's bank. Now, this not only in itself requires a proof, as the pursuers in their pleadings deny the need and the need for that sum, but it is also an invalid claim in law. As my lord is well aware, damages in Scotland are compensatory in nature, and they're designed to to put the innocent party back into the position that they would have been without the breach. It is my submission that the sum sued for in the counterclaim goes well beyond this, as the defender at all times would have had to have bought material and hire both the plant and the employees to lay it. The defender has not lost anything other than the price of the original material which they claim to be defective and the expenses of removing it. That is all. Now, it's not the purpose of this debate to discuss and argue damages. However, the key point in this regard is that the sum sued for by the defenders is not easily verifiable. There is still to be a proof on the actual figure of expense, and then there's a further legal argument to be had. The defender's case for retention, it falls at the first hurdle. Now, in terms of the mutuality principle, which is the second exception to the rule that a liquid sum cannot be offset against an illiquid claim. Now, the defender does no better on this doctrine. There is absolutely nothing to suggest that the supply of materials on 12 separate occasions fell under one contract. Indeed, quite the opposite. There are 12 different and separate contracts. There are 12 different and separate invoices. And on each occasion, the defender approached the pursuer on an individual basis. Even if my Lord finds that this constitutes a course of dealing, in the words of Lord Osborne, each invoice represents a different transaction. Therefore, transactions 1, 2, 3, 4 and 12, which was the supply of the goods to Alloa, Edinburgh and Bothwell, has been duly performed without exception, and the pursuer is entitled to payment. The defender is not entitled to retain this clear and identifiable sum of money in the hope that their fishing expedition of a counterclaim may succeed. So I submit that this is the case for all of the invoices except those concerning the Kirkcaldy site. And in short, the defender is not entitled to retain £18,000 of liquid debt to offset their yet to be decided counterclaim, because the claim has not and is not easily verifiable, and in any regard it concerns entirely different transactions to the sum sued for this afternoon. Lord, I'll now move on to my third and final submission, where I will submit that my Lord, whilst entitled to do so, should not apply judicial discretion to find in the defender's favour. Lord, this is quite a short submission, but it is quite an important one. I submit that it is not fair, just, nor reasonable to ignore the established principles that I've already set out on the basis that the pursuer has not done anything that would suggest otherwise. By all accounts, the pursuer has provided good service to the defenders time and time again. The pursuer's condescendence in answer to the counterclaim shows that the pursuer has a prima facie defence, and a strong one at that. Lord Drummond-Young, in his opinion, in Purac, suggested that it might be taken into consideration whether or not the fundamental basis and benefit of the contract would be undermined in the event that retention cannot be validly pled. As previously mentioned, this suggestion has not been supported by preceding authority. However, even if my Lord accepts this suggestion, I submit that this test weighs far more in favour of the pursuer than the defender. Indeed, it would be unjust unfair and unreasonable for the court to find against the pursuer in this matter. The pursuer, on 12 occasions, has supplied the defender with material, and on at least 5 of these occasions, the defender has used them and had the benefit from them, whilst the pursuer goes unpaid for all of them. It is my submission that the balance of convenience falls very clearly in favour of the pursuer. So, my Lord, in summary, I've invited my Lord to make 3 key findings. Firstly, I invited my Lord to find that in Scotland, a liquid claim cannot be offset against an illiquid claim, and the plea of retention is invalid in such circumstances, bar some very narrow exceptions. I've secondly invited my Lord to find that on all of the facts and the circumstances, the sum sued for by the pursuer is a liquid sum, and the sum claimed for by the defender is an illiquid claim, and the plea of retention is invalid in the matter at hand. And I finally invited my Lord to find that on the doctrine of judicial discretion, it is unfair, unjust, and unreasonable to find against the pursuer. I therefore move my Lord to grant decree in favour of the pursuer for the sum of £18,000, and I invite my Lord to fix a proof on the consignment of materials to the Kirkcaldy site and the remaining £25,200 in terms of the pursuer's first crave. If I can be of any further assistance,